Rule 1.0.1 is titled Terminology. It contains 15 definitions. I will paste them all in the description for easy access, but I'm not going to go through all of them in this video because there's no need. Just the few that I think are most important and most confusing. This continues my series on the rules of professional conduct, and if you want to stay up to date on the rules, and also my other videos about law practice, don't forget to hit the subscribe button. First, the word firm or law firm does not include lawyers who share office space or occasionally consult with each other, or even assist each other sometimes. But if they hold themselves out to the public in a way that suggests they are a law firm, then they might be regarded as one for purposes of the rules. Also, some relevant information in considering whether two or more lawyers constitute a firm is whether those lawyers have any formal agreements between each other, or if they have mutual access to client information. Along these lines, the term of counsel implies a close, personal, continuous, and regular relationship between that lawyer and the firm. The next definition I want to cover is fraud. For purposes of the rules, fraud means conduct that is fraudulent under the law and has a purpose to deceive. But unlike in a lawsuit, it is not necessary for anyone to have suffered damages or even relied on the misrepresentation or omission. It needs something more than negligence, though. The terms informed consent or informed written consent are important because you might think that you have received informed consent from a client, but the definition is specific about two crucial items that you must explain. First, the relevant circumstances, and second, the material risks, including any actual and reasonably foreseeable adverse consequences of the proposed course of conduct. So keep in mind that if another rule requires informed consent or informed written consent, then you can't forget to inform your client of the reasonably foreseeable adverse consequences. And informed written consent is not just that the consent must be in writing, but also the disclosures. Although best practices dictate that disclosures should always be in writing, even if there's no specific rule requiring it. The last definition is screened, and it does not mean what you might think it means. This comes up in rules involving conflicts of interest. In that context, it means to isolate the lawyer from participating in a matter, including protecting the information that the lawyer is obligated to protect, and also protecting other law firm lawyers or non-lawyers from communicating at all with the isolated lawyer with respect to the matter. With any conflict of interest, the key concept is to protect confidential information. And the comments to Rule 1.0.1 make it clear that the purpose of screening a lawyer is to protect that information from disclosure to other lawyers or non-lawyers at the firm. What you might not know about rules that require screening is that the screened lawyer has to acknowledge the obligation not to communicate with other people at the firm with respect to the matter, and that other people working on the matter must be promptly informed that the screening is in place, and informed that they cannot communicate with the screened lawyer with respect to that matter. That covers the rules regarding terminology. Don't forget to subscribe. My next video will cover Rule 1.1, which discusses competence.